Yes, ladies and gentlemen, without any further ado, I'd like to call upon Dr. Foca to give us her reflections on yesterday's proceedings. General Secretary.
Thank you, Program Director. Good morning to the audience. Today we are pressed with time, so I'm going to take literally 2 minutes. I need to apologize to the speakers in advance. It's not to downplay the input that you made yesterday, but because of in the interest of time, I need to cut it very short. And as I'm doing that, I need to also remind, as the Program Director has been announcing, that on the program we have a QR code. When you scan it, it has all the presentations and the inputs. So please visit that website of ours so that you read more in terms of what was presented. I want to start off with session 1, Professor Benjamin. I think he emphasized on the importance of balancing employment protection with other social factors. So you can see the pattern. Almost all the speakers are in sync with what we need to be reflecting on. However, he said the challenge is to find the right balance between the workers' protection and the flexibility. So as we go back to reflect, we need to be asking ourselves, to what extent is the legislation allowing us that level of flexibility? Then he also made mention of the fact that we need to consider the application to education sector in terms of how do you apply the general employment legislation, in particular to the LRA. I think my chairperson reminded the audience yesterday that the unique feature with the LRC is that we existed prior the promulgation of the Labour Relations Act. So I don't want to say the drafters of the legislation failed us by doing copy and paste, but we always hold the view that there was no justice done to what was already there in education in the form of Education Labour Relations Act. Because we were simple grouped together with the bargaining councils. I don't see my dear friend of mine, Muso. Hi, my friend, still my friend, but we were we were there before Triple SBC. So the assumption was that we must just fit in with the LRA and under the umbrella bargaining councils within the public service. Now this is where you find yourself navigating in a situation that is very difficult to manage, but we'll get there. Me and my chairperson, in his other capacity that I don't want to mention, we're going to see how best we manage. But what is also important, which we always raise, even with our commissioners, that when you come to be a panelist at the LRC, it's not a cut and dry thing. Because you could tell, Professor Benjamin confirmed that employment legislation within education sector is a very complex issue. You can be a great practitioner in terms of employment legislation, but the employment laws, and again, they are normally exist because of us having been in existence prior the promulgation of the LRA. So as we leave the sitting or the seminar, those are some of the discussions that we need to take up and see how best we formulate submissions such that at NETLEC, when there is a process to review this legislation, in particular the LRA, what can be done to address generally the public service, but in particular education sector. Then we move to the chairperson of Triple SBC in his capacity as an expert in the field. He provided us with very crucial information in terms of the statistical analysis in respect of the labor force. He taught us, or he gave us very good lessons on the inherent nature of conflict due to differences and the need to engage in a much more matured way. because beyond the grievance, beyond the resolution of the dispute, you need to safeguard the working relationship. I think one of the speakers from the floor, when he was posing the question, he said, how best do we respond to a very disturbing trend where even the misconduct committed, the employers would insist and say the relationship is irrevocable, is broken down. And that is the excuse that the employers use when they want to get rid of you, Glenys. The misconduct is very minor and minute, but the employer is willing to pay you your 3-month settlement as long as they get rid of you. We don't want that. As a bargaining council, we're saying we can't allow that situation. And then we come and lament a high unemployment rate, but we are contributing. The employers are contributing because they just want to push the workers out of the system, putting reliance on this relationship that is broken down. So that is, in other words, trying to re-emphasize what Patilia was raising, to say, before we run to bargaining councils, we go and call experts, we run to the labor courts and so forth. Let's find solutions internal. And when we do that, you are safeguarding and protecting the ongoing relationship that has to exist beyond the resolution of a grievance and or the dispute. Session 2, Prof. Reinecke. I don't like summarizing when the speakers are in presence. It's easy with the others because they've left, because they don't know what I'm saying, even if I'm misrepresenting them. So I'm intimidated when the speaker is amongst the audience and she's staring at me. Apologies, Prof. She gave us significant lessons in terms of the consideration of national and international legislation and the legislative framework that is there. To what extent, when we take decisions that affect the learner as a child, do we have that consideration at the back of our minds? That talks again to that principle that was established on day one. How do you ensure that this balancing act does not in any way mean that you are saying the rights of the worker, which are guaranteed by the constitution of the country, are put at the lower end because you are saying, no, I'm guided by the paramountcy of the best interest of the child. Best interest of the child. The constitution does not say the right of the child, Glenys. It says the best interest of the child. I know we're lamenting on nomenclature, but it's very crucial because we always talk about these terms interchangeable, and that's where we miss what needs to be done. We have to, when we talk about the state DG cutting education, educators' posts, how do you convince us as the ELRC that in taking that decision, you have taken the best interest of the child? So we want to be convinced it cuts across. When we're dealing with issues of discipline, we have to ensure that we consider the best interest of the child. When you come and tell the education social partners, Manya is not here, we insist they are social partners. Please relay the message to him. How do you convince the social partners? You wake up and you say, I'm cutting 5,000 posts. How have you considered the best interest of the child? Because that child has to be guaranteed access to quality education. I can't deliver curriculum to a classroom that is intended to have 25 learners. Now, because the state has reduced 5,000 posts, I must deliver that curriculum to a classroom having 70 kids in the classroom. So you are violating, you have not considered the best interest of the child. But I'm not here to be controversial, I'm just illustrating practical that the obligation cuts across. It's not only limited to discipline. Then the challenges that she highlighted is the unavailability of social services. Again, we can't be fixated to academic performance. We need to ensure that the foundation has been laid. And part of that is to attend to the emotional state of the mind. These kids are looking after their parents, they are abused daily in the communities and so forth. So if you do not have such services, you can't guarantee that they are going to excel academically. So we need to talk about these issues, and the state has got an obligation to provide, of course, with the minimum resources that they have, but we have to get to that point. Then we had Dr. van der Walt. I think the case law, I was sitting here and I was saying to myself, my goodness, I'm tempted to go and enroll Prof for a second doctorate. Because the topic for research, I mean, the case law that we were favored with, they're giving us a lot to go out there and explore and develop and contribute to the development of body of knowledge. I'm looking to a candidate that I would want to supervise, Prof, because she's sitting with a master's degree, so she needs to apply. We want more academics, we want researchers, because this research has to inform these recommendations that we need to put forward for the purposes of amending the current legislation such that we respond to the material conditions. You can't be sitting with one piece of legislation that was promulgated ages ago, but the common law has developed. And people always go to that piece of legislation. Very few people make time to research and see how have the courts interpreted the application of this section that is contained in this statute. So it's very crucial that we encourage that we continuously contribute to the development of the body of knowledge, because it makes things easy. The application and the interpretation of legislation becomes very helpful when we have researchers and so forth. I think also Glenys emphasized the importance of ensuring that there are processes dealing with these issues that are affecting children, which should be child-centered approach, because we again reminded that we have to consider that in this decision-making, we have to take into consideration the balancing act, the best interest of the child, and the rights of the individuals involved. In this instance will be your teachers. Then we had Dr. Maluleke, who illustrated that not only is he the general secretary, but he's the president of Education International, because the examples and also the application and his paper was centered more on what is applicable in other jurisdictions, what is done in Canada, Germany. You know, there's one thing that when we talk with my chairperson and other colleagues, we say there's always this complaint from the teachers, understandable so, because when we talk about the salaries that we earn, we're more worried about the take home, how much am I taking, how much am I getting in my bank account. But research has shown that education teachers or the educators in the country, one, they've got the best benefits. The salaries that are paid are not comparable to what teachers are paid in other countries. And I'm not saying we should not demand your double digits, but I'm saying at least we must take time, Basil, and appreciate that we are cited as an example when international these matters are discussed, but there's still room for improvement because everything has got its own context. Our inflation is what is making us not to see the value of these salaries that are paid to the teachers. So when you compare issues, you must compare apples with apples, but doesn't mean that you can't pick up on what is there with the bananas that can be imported over to your apples such that you have the best produce. So we then had Advocate Manya, my controversial friend, who attacked me as if we're not going to be friends beyond this conference. But I must say, the reflection and the criticism, we take it with, with humility. Because for us, it is to say, how do you go back and enhance your processes? I always complain to my quality assurers to say, I can't appoint senior commissioners to do quality control on the awards. Then I must be told, by the representatives of the parties that the LRC commissioners are doing copy and paste, because that quality assurance is not only in place to ensure that the application of the law and also the decision is rational, but even the basic stuff to say the citation of the parties, the issues that are in dispute are correctly cited, because Manya's fight with me is centered around that. He's saying, why must my client be frustrated purely because your commissioners have failed to do their work? So we accept that, and we always ensure that through our ongoing training and development, we address that. But the other area that we agree with him, which I think the previous speakers also spoke at length to say, the bargaining councils were established to ensure that you minimize litigation in the labor court. But we are not achieving that because we are confined by these restrictions that I can't review my own award. But there are issues where you see that there are patent errors committed by the commissioner. But I'm dealing with commissioners who are refusing, even when I ask them to say, look, consider rescinding this, because why should the union go to the labor court DG, wait for 8 years? But you have taken a decision based on an outdated policy. The former accounting officer, the provincial head of education, has written an affidavit on behalf of the parties to the dispute to say, I support what the union has raised, that this policy is outdated. But the commissioners are independent, unfortunately. Then the commissioner says, no, I note the affidavit from the former HOD that indeed this policy that was submitted by the employer at the time of me hearing the case is outdated. And as such, the new policy requires me to find in favor of the educator, but I do not want to review my own award. But rescission is there, but he refuses, and I can't force him. Because as much as he's my agent employed by my office, he has to maintain his independence. So these are the issues that we want to take up as the processes of revising and amending the Labor Relations Act, such that we consider what is it that needs to be corrected. So we will definitely relook at our rules and make the necessary submissions. But one thing which my chairperson also highlighted was that we've got one of, without blowing our own horn, we've got one of the best constitution when it comes to our rules for dispute. We were challenged even by the CCMA. Cameroon is not here. They were saying, no, we've given ourselves jurisdiction to deal with matters under normal circumstances should be referred to the CCMA. We stood our ground and we said, if you want to take us to court, bring it on, we'll go and defend our constitution. But we were able to settle the issue, and as such, we're dealing with those type of disputes. Then my former lecturer, Mr. Q, Kotoi, I think, colleagues, I can't overemphasize the importance of what he presented. The employers must not delay taking the action. We are not encouraging that workers must be charged. But you can't leave it now. Then 8 months after the fact, because now there's something else that has irritated you, you go and resuscitate the charges and you want to charge the official, because it creates problems in the system. One area, as I conclude, Mr. Q, I think yours was simple, premised on one principle: justice delayed is justice denied. So you can't delay because you are creating bottlenecks. We're not encouraging. Remember, you need to reconcile this with Patelia's presentation. Find ways to resolve these issues internally, amicable, so to protect the relationship. But if you feel you need to subject an official to a process, do not delay, start the process early. My colleagues on the right-hand side, the unions, I know that we always feel comfortable not to worry about following up on the outcome of the appeal, Greg, because we always say, for as long as that appeal has stayed the execution of the sanction, my member continues drawing a salary. But it catches up. Where? It catches up with the member because if at the time eventually that appeal is upheld, the sanction is upheld, what then happens? The state recovers every cent that worker has received from that time that the sanction was issued up to the date of the decision. And it's not by our own doing, again, it's by the court's decision. So as you are waiting the outcome, Basil, of the appeal, we must also make it our business to push the executive authorities, the MECs, to finalize the outcome because it disadvantages the worker in the event that that worker is still dismissed. Because all the monies that would have been paid from that date, they then are recovered. Thank you very much. All the best.
Thank you very much, General Secretary. Ladies and gentlemen, this now brings us straight to the second session for the day. We're getting into it now. And of course, social media has indeed turned us into one big global village. And with its uses also comes great responsibility. So today we will be taking you through conversations on social media, artificial intelligence, employment equity, and bullying in the workplace. Without further ado, ladies and gentlemen, let's get straight into it. Prof. van der Walt, I please call you to come onto the stage to give us your presentation on the legal regulation of social media in the workplace and schools.
Program Director, President of Education International, the Chairperson of the ELRC, the General Secretary of the ELRC, and representatives of employers and trade unions in the education sector, representatives from other public service bargaining councils, and friends, and other friends. Thank you for giving me the opportunity to speak to you this morning. Really from a layman's perspective, as it were, because it's ironic. I know many of you, but those of you who know me well would know it's probably the last topic I should speak about, because I only really started working on WhatsApp like 2 years ago. and on email probably 3 years ago. But nevertheless, I'm in the deep water, and I trust we can gather some information, even from me. So thank you very much. Let's see if this thing works. You see, this is what technology never works. Program Director, was appointed where? There we are. No. I do. Ooh. I think you must sit here.
Are you good now with that?
No, I'm joking. No, I'll press it. I must be in control. Yeah, I mean, I'm retiring this year, and my whole life as an academic, I always had people around me because I like people, but also I always had students and student assistants around me because I like to create jobs. But I also do it for myself because I need them all the time. Because whenever I'm involved in technology, there's a hiccup. Okay. Right. So I must say, I think you're going to be impressed with not my speech necessarily, but with my PowerPoint presentation. And it is because I didn't do it. Well, I did it, the content, but then I had two very advanced assistants, Dr. Shasakara and Dr. Maseko, who's sitting there at the back, who actually took 2 hours yesterday to bring my PowerPoint presentation up to speed, up to standard. Don't you think it's beautiful? So thank you very much. Thank you very much for that. All I had to pay was chips and red wine. Right, so the definition for social media is that websites and applications that enable users to create and share content or to participate in social networking. So we've added probably the most used types of social media that we face today, that we have today. And the statistics about this use of the social media is that recent studies conducted by Forbes, it was found that in July 2024, there was 5.4 billion internet users worldwide. This amounts to 67% of the global population. Out of this total, an astonishing 63% of the world's population are social media users. This information I got from the SAOU, from Dem Snell, from the legal services at the SAOU, and from Annerieke Gray. Interestingly enough, I mean, the SAOU members will benefit from a newsletter that has been sent by the SAOU this week, dealing specifically with social media. I suggest the other unions speak to the SAOU and ask that newsletter, which is concise and very useful, could be shared perhaps with all the trade unions and members in public education. So I acknowledge them also for the finding of these statistics, and then the very last slide will also come from that newsletter. So thank you very much, Dems. There are, of course, significant advantages of social media in the workplace and in schools, and we particularly, I mean, people, especially people like me, really learned, well, we were compelled to learn social media or aspects of social media and technology during the COVID period. So the advantages include, well, facilitation of advertising, thought sharing amongst colleagues, and the cultivation of relationships within organizations. And much of the work performed nowadays by employees in the workplace are performed via social media. So there's such an enormous impact that it has on our working lives that it is necessary to perhaps look a bit closer at regulating to an extent the use of social media and the possible consequences for employees as employees and in using social media. So globally, social media has impacted life in recent years, has grown exponentially, as we know, and organizations have pushed to incorporate social media tools into the workplace. I mean, isn't it so? You all have WhatsApp groups. We all get information of what's going to happen next at the university because we haven't had electricity in Gqeberha for the last 7 days. Luckily, I'm here. Because it has such a serious impact on the students, on classes, on assessments. So how will we get all this information quickly to everybody if we didn't have WhatsApp groups? But social media blurs the lines between the work and private spaces because it's not two separate aspects, two different types of social media. We use our social media both privately and in work that we perform for our employers, and that often creates the problems and difficulties. So the focus of this paper, isn't that impressive? Is to explore the complex domain of social media, focusing specifically on its effects in the employment relationship in the workplace and the school as a workplace. So that's from now on, we're talking about the consequences of social media and the effects on the employment relationship, specifically the employment relationship. So the limitation of the paper is that it does not specifically, and that is even probably more of a minefield, is social media and pupils and learners and what they do with social media on learners. I mean, you can see something happens in the school, and within 10 minutes, the whole of South Africa sees the images of a fight or an assault in South Africa. So I'm concentrating on the use of social media by employees. The workplace has been transformed by the integration of social media by employers in the workplace and in schools. The shift has introduced complexities and the risk for employers and employees, various risks during the use or by the use. We've seen that. It always often makes news if there's a photograph that circulates on social media where a teacher grabs a child and cuts his hair, for instance. That's immediately known to everybody. Particularly in the absence of social media laws, and that's really what we talk about in the employment context of South Africa. And then the point of the first three bullets there is that it is not specifically regulated in the employment context. We know that now in South Africa, the use of social media, of course, is so widespread, and the effect is so widespread that in general society, there has been legislation promulgated, the Cybercrimes Act and the Hate Speech Act, which must still take effect, but the Cybercrimes Act already takes effect, which makes certain actions also on social media, like crimes. So the Cybercrimes Act, for instance, makes it a crime, an offense, to instigate violence on social media posts since 2021. And we know that followed the chaos we saw, particularly in KwaZulu-Natal and in Gauteng a few years back. So it's not true then to say there's no regulation. There's definitely now a beginning of regulation in a criminal context, but not bless you, not in the employment context yet. So employers struggle to manage social media use, leading to risks such as delictual and contractual claims, unfair dismissals, harassment, bullying. Josa will speak about that. Unfair discrimination, and the loss of intellectual property. Relevant laws regulating social media in the workplace are the LRA, the Basic Conditions of Employment Act, the Employment Equity Act, and in schools, the Employment of Educators Act, and the relevant regulations published in terms of these laws. Not regulations specifically dealing with social media, but regulations that can be used in instances where there's consequences, legal consequences of social media use. So what is social media misconduct? Just as an aside, quickly, we're going back to that. It includes cyberbullying, and that will be talked about by Zuleka, defamation, and various other consequences, legal consequences of social media. I'm going to look briefly first at the Employment Equity Act. How is that act, how can it be used? How is it used in social media controversies? That act, of course, tackles two areas. The prohibiting of unfair discrimination in Section 6, and then the promoting of affirmative action. And we're specifically talking about the first bullet, Chapter 2 of the Employment Equity Act, because much of what comes before the courts in the employment contract relating to social media concerns either harassment, and harassment is seen as unfair discrimination if it's on a prohibited ground, or then unfair discrimination covered or protected against, employees are protected against it in terms of Section 6. Now, in this instance, there are three cases that I just want to refer to. The first one is Stradom versus Chiluane, in which discriminatory comments were deemed illegal, thus highlighting the Act's role in addressing hate speech. However, complexities arise when considering social media in an absence of specific EEA provisions on the topic. The second case is the one of Gareth Cliff in Cliff and Electronic Media, where Gareth Cliff, you remember, he made comments on Twitter following was it Sparrow matter from KwaZulu-Natal, where his comment following, there's a big controversy, quite rightly so. This Ms. Sparrow was condemned and eventually served imprisonment for her social media posts, not in the employment context, but in the general context in terms of Pepuda, before an equality court, concerning, which was a racist comment, a serious and disgusting racist comment. But Cliff then tweeted that people don't understand free speech at all. And as a consequence of that, Mnet then cancelled his contract for the next year in South African Idol. I don't know if you recall this case. And he then he applied for launched an urgent interdict application against this decision, which was really a contractual case between Mr. Cliff and Electronic Media Network. Now Mnet resorts under that. And the court is an interesting judgment where the court again balances the interests of the two parties, and it came to the conclusion that Cliff himself, in tweeting this, was not a racist. He did not propose to support Sparrow's action at all. He was actually supporting the notion of free speech. And that's the balancing often that has to take place, is the issue of free speech and the issue of hate speech. So in this case then, the case illustrates the need to balance employer interests with the employee's rights to free speech. At the same time, the decision of Mklong versus the Market Theatre Foundation reinforces the potential consequences of online hate speech. To navigate this complex landscape, employers can rely on a code of good practice on the prevention and elimination of harassment, published in terms of the EEA, and this document provides guidelines on identifying and addressing online harassment. So there is that harassment code that does deal with online harassment, including specific examples like spreading rumors and online bullying. But I leave that also to the speaker after next. We then turn to the Basic Conditions of Employment Act that typically provides as main goal to put into effect Section 23 of the Constitution of the Republic, which guarantees the right to fair labor practices. To avoid unfair labor practices, minimum terms and conditions of work must be set, and boundaries for contractual agreements between employers and employees must be defined. And that's done in terms of the Basic Conditions of Employment Act. Now, in regard to social media and the use of social media in the workplace, this act has application in at least two respects. There are, of course, more, but I mean, I'm highlighting two. The BCA set minimum terms and conditions of work and boundaries for contractual agreement between employers and the employees as they are defined, as I pointed out. Fundamental legal principles relating to social media are embodied possibly in Section 15 and Section 78 of the BCA. Section 15 delineates rest periods. And I just want to dwell a second on this because, and I have the experience of this as a worker, that when you have now reverted to or moved to a chat group on WhatsApp for your department, then the head of department believes you are on call 24 hours a day and give you instructions on the WhatsApp to be done ASAP. And that may happen at 10 o'clock at night or on a Sunday. So the rest periods that employees are entitled to are defined or explained in the Basic Conditions of Employment Act. And employees would have the right to have these rest periods. And they could rightfully argue that imposing instructions or requirements during the rest periods online would not be in accordance with the obligations of an employee. So that's one part, one aspect that has become significantly prevalent in the workplace. Section 78, furthermore, guarantees employees, I think there's employers, the right to discuss conditions of employment. It's Rachel and Tamesha's fault that. So the word should be employees. So, contrary to general understanding, it is perfectly allowed for employee to discuss with his or her fellow employee what his salary is or what his conditions of employment are. Employers don't like that, and they often prohibit that in the contract of employment, that all your conditions of service are confidential between you and the employer, and you're not allowed to tell anybody about it. And Section 78 of the BCA provides differently. Now the question is this discussion, does this discussion also include discussions on WhatsApp? And there are some tentative cases suggesting that they are protected, that there are protected discussions as if they were discussions in person or a personal note or letter. So that's the other aspect of development is the second, Section 78 of the BCA. So the absence of specific legislation, so in the advent of social media, particularly WhatsApp, has revolutionized communication in the workplace, but the absence of specific regulation on WhatsApp groups still raises concern. I've mentioned what is apparent from the Basic Conditions of Employment Act. We can perhaps get foreign law inspiration, interestingly enough, from Trump's place, drawing inspiration from the United States. The National Labor Relations Act recent decisions indicate that WhatsApp messages may be considered protected activity. However, the BCA's failure to define protected discussions in relation to social media exposes employees to potential dismissal. So it's actually a gray area and should be considered to be addressed also by our legislature or by the promulgation, and that's really what I suggest is the passing of soft law, of codes of good practice. If we look at the Labor Relations Act here, we specifically speak about, in most instances, misconduct cases. The Labor Relations Act plays a crucial role in shaping the employment relationship, emphasizing fairness and adherence to due process in dismissals. Challenges arise in the context of social media misconduct, particularly concerning posts made outside the regular working hours. A central dilemma emerges as employers and employees may perceive social media misconduct differently. Of course, employees see it through glasses of freedom of speech, and the employer sees it from you are not in a position to sort of break down or hamper the employment relationship, and you as employee, your fiduciary duty towards the employer, which is a duty of acting in good faith in regard to the employer at all times. The challenge of addressing social media misconduct becomes evident as courts and the CCMA and Bargaining Council grapple with the interpretation and application of item 7 of the Code of Good Practice dismissals in relation to employee behavior on social media. So social media behavior that may constitute misconduct would have to be determined and addressed as being fair or unfair with reference to item 7, the very well-known code of the Labor Relations Act. There's an absence of clear guidelines, and many employers lack social media policies. I think that is what we face currently in South Africa, and that needs to be attended to, because as we know and see, we're always on not me, always on social media. There are always exceptions. But look at Advocate Dr. Professor Bono is on social media. So there are a few cases. I haven't had any notices from the back here yet. Is it coming? How long? 15. No, I'm going to be shorter than that. You're going to be happy. Is briefly to discuss, refer to these cases, Sedig versus Crisray, in this context. This case exemplifies the importance of social media scrutiny. The employee's derogatory Facebook post led to their dismissal for damaging the employer relationship or employer's reputation. The commissioner ruled the posts were in the public domain owing to the employee's failure to restrict access. There's also another case that takes it further. It's Smith versus Past Partners in Sexual Health, involved an employee dismissed for private Gmail emails that had been accessed intentionally, involved in this Gmails that had been accessed intentionally by the employer, violating privacy rights. So in this case, the employer was on like a witch hunt and befriended the particular employee, wouldn't have had access, a manager of the employer, and then as a result of that, Privacy Access had access to the emails, and the commissioner found that was unfair, and that in the sense that there was no misconduct committed. The CCMA deemed the dismissal procedurally and substantively unfair. In Siyaya Skills, a case where racist comments on Facebook led to a fair dismissal, and despite the lack of a policy, the CCMA guidelines on misconduct arbitration justified the employer's action. In other case, the second case that I will speak to is Fredericks with his Joe Barkett fashions. It's quite a well-known case. The employee disparaged a general manager on Facebook with multiple comments. He was really upset with the general manager. And Joe Barkett Fashions, of course, is a well-known brand. The employee's comments were abhorrent and upsetting, to the point that she even called the manager names. The statements were disclosed in the broader public, and the consequences would have impacted 90 employees and critical clients who were the source of revenue for that organization. The employee exhibited a lack of regard for both the manager and the organization as a whole. So following an extensive inquiry, the employee was indicted. Given the nature of the posts on Facebook, an independent chairperson presided impartially over a hearing, culminating in the employee's dismissal. Although the organization lacked a specific possibility regarding Facebook usage, the employer contended that the employer had violated the terms of a contract, and in that she had published derogatory statements about the company and the general manager. The arbitrator and court concurred and found the dismissal to be fair. In Gordon versus National Oil Well Vanco, this case involved an applicant who was charged and dismissed for posting discriminatory comments on social media. Following his mother's injury in an ambulance hijacking, the applicant explained or expressed his thoughts on Facebook as follows. My mom is back in hospital again since last night after her ambulance got hijacked by pieces of this, wanting a ride with the ambulance for their effing knife stabbing. I'm getting fed up with this country. Will it ever come right again? I doubt it. Maybe just move out of the country. The employer presented evidence that the applicant was cognizant of the company's social media policies, which it had, as he had affixed his signature to then, upon commencing employment. So he read the policy, and they had a policy, and this was clearly contravention of the policy. He maintained his defense that the remarks were published out of desperation. Nevertheless, the commissioner determined that using racist obscenities in the workplace was unacceptable, and thus the applicant's employment was appropriately terminated. In the Siyaya case, I've gone on, the fifth case that I've referred to, the commissioner was tasked in determining whether the applicant was dismissed fairly. The applicant's position was terminated owing to his dissemination of bigoted remarks on Facebook and for tarnishing the employer's reputation. The applicant had made the following comment. We must eliminate the Boers. According to the respondent, kill the Boer was a disturbingly prejudiced remark, and the applicant had published it on a public Facebook page. The applicant contended that the phrase kill the Boer did not refer to white individuals per se, but rather to the oppressive system that it exists to subjugate one group. He contended that he did not believe that would be offensive to white individuals because he maintained friendships with white people. You often hear that. And his close associates, his close associates, no, just 15, now it's 5, you. And his close associates, must be the white people, did not find it offensive. Despite this argument, he lost and the commissioner found the dismissal to be fair. Right, so I'm moving on. The LRA Code of Good Practice and the drafting of guidelines relating to social media policies should be considered in going forward. Item 7A of the Code of Good Practice, dismissal, is important already. I mean, you need to look at that to determine whether, as an arbitrator or as a chairperson of a disciplinary inquiry, whether there's enough evidence to establish a substantively fair dismissal in the case of misconduct, whether the misconduct meets the requirements of Item 7. So the item requires employers to prove the existence of the contravention of a rule. And in this case, a robust social media policy must be made or should be made in order to establish, like in the one case I referred to establish that the employee breached the rule and that the rule was known to the employee. So, essential components of a social media policy would be monitoring provisions, guidelines on copyright material, specific penalties for policy breaches, and clear distinctions between personal and professional use of social media. These are just some thoughts of what should be included in a social media policy. There's a need for guidelines in the form of a code of good practice, so it's moving away from the actual policy of a particular employer. is guidelines in the form of a code of good practice to prevent over-regulation and employment terms. Guidelines to protect employees and employers' rights and to offer clarity on what constitutes reasonable terms on social media policy should possibly be drafted by NEDLAC, the CCMA, or the ELRC, specifically for the regulation to an extent of social media use in the public education sector. But the point is made that, in my view, too, it could not really be specifically in detail regulated in an act of parliament, but rather in the form of soft law or in the form of a collective agreement. Practical examples with the guidelines would enhance the effectiveness in balancing employer and employees' interests. And then finally, back to the SAOU, to DEMS, what can the educator do? If you see the newsletter, there's a whole list of very thoughtful suggestions that an educator can adopt in avoiding the pitfalls of social media. And I just chose 5. Always remember that educators are held to a higher standard of professionalism due to the nature of working with and having the responsibility to be the role model to students. Well, that's really students, including learners. Avoid accepting the friending of students on social media. Glynis spoke about that yesterday, where the principal of a particular school here in the Western Cape really wanted to befriend a pupil, and he used social media. Tread extremely cautiously and act professionally in the event of communicating with a student. Via social media. Limit communication and interaction with learners via social media altogether, unless, I suppose it's useful to have class WhatsApp groups, but keep it, don't make it private, don't make it personal. Have clear boundaries, rules and regulations when using social platforms such as educational tools like WhatsApp groups for students, etc. Right, so with these few thoughts, I'll entertain some questions at a later stage. Am I in time?
Yes.
I'm the first, so that you can clap me for, I'm the first person that stick to the time.
Thank you so much. Grab a seat there. Grab a seat. Yeah, for sure. Thank you so much, Prof, for that. Ladies and gentlemen, we'll now move to the fair use and artificial intelligence. The substance changes proposed by the Copyright Amendment Bill could do untold harm to the prospects of future generations in South Africa, and that will be presented by Prof. Kajika from the Stellenbosch University. Yeah.
Is that forward?
Yeah.
Okay, forward.
Next,
Okay.
yeah.
Thanks. Good morning, everyone. Thanks to the ELRC for the invitation. I feel like a bit of a square peg in a round hole here. This is not my normal audience, and this is probably not the usual topic for you, speaking about copyright, but it is an incredibly important topic in South Africa. Intellectual property in general, I think, is very important. And my role as the IP chair is to educate people about intellectual property. And before we can get on to speaking about the proposed changes to the Act and things like artificial intelligence, it's necessary to know a bit about the law. So I ask for your indulgence to explain the law to you. And by me explaining the law to you, I'm really not, infantilizing you or patronizing you to teach you the basics of copyright law. The sad reality is that actually most law graduates, most lawyers out there, most advocates out there, most judges out there may have never done a subject like intellectual property law. At most universities, it is at most an elective subject. And that means, for example, at Stellenbosch this afternoon, I will go teach my elective class, yes, on a Friday afternoon. I teach it from 3 o'clock to 5 o'clock. So as you can imagine, I'm not the most popular lecturer. So only about a quarter of the class will take the subject. So that means 3/4 of Stellenbosch graduates this year will graduate without any knowledge of intellectual property law. So it's not a subject that is even understood well by lawyers. So, and these are not my words. This is from case law that still describes the subject as esoteric. But it's hugely important because you are actually integrally connected with the subject, believe it or not. So what is copyright law? So copyright, and this extends to intellectual property law more generally, what intellectual property law seeks to protect are that which we create with the mind. That's what we use our brains for, what we use our creativity for. That is what this area of the law protects. It protects intangible creations. And this is an incredibly powerful thing. And you'll see with copyright, I always say to my students, and that's why I feel so passionately about this subject, is that it is the cheapest form of property that you can own. Doesn't take much. A little girl living in abject poverty in a shack, all she needs is a piece of paper and a pencil, and she could write the songs to a hit song, the lyrics to a hit song. She could write a novel that could turn out to be a bestseller. And just by creating that work, she would acquire a property right in her creation. Without any government bureaucracy, she doesn't need to pay for it, she doesn't need to register it with any government authority. That is what copyright can do and what it seeks to protect. So what does copyright protect? So that's just a quote from a standard textbook on the subject. So copyright, and this is the other thing I tell my students. Because so few students and lawyers get to study intellectual property law, you can quickly discern whether somebody has intellectual property experience and an understanding from how they use legal terminology and jargon. Because people who don't know the field will get terms horribly confused. So you'll hear people say things like, oh, when they've said something which they think is funny, and it's generally a he when he's drunk, he says, oh, I'm going to copyright that idea. Well, then you know your friend had too much to drink and knows nothing about intellectual property law. Because copyright doesn't protect ideas, right? Or somebody says, ooh, I'm going to patent that joke. Have you heard things like that? Well, again, had too much to drink, because patents have nothing to do with jokes. And, it's little things like that that show that people don't know what various forms of intellectual property protect. So copyright protects certain types of work. And the Act specifies what it protects, so things like artistic works, literary works, musical works, films, that type of creation. There are 9 types of work that copyright protects. And the Act requires that the work must have been reduced to a material form. So you must have given expression to your idea. So there's a sort of a rule of thumb that we use. We say that copyright doesn't protect ideas. It only protects a particular expression of an idea. So to illustrate this, nothing stops anyone from writing a book about a little boy going to magic school and having 2 friends. And this boy goes on a series of adventures and incidents. There may be a book out there that broadly fits this notion, but it doesn't stop anybody else from writing similar books. My nieces, they're a bit older now, so maybe they'll be embarrassed by this, but when they were teenagers, suddenly everybody wanted a vampire boyfriend. I don't know why. And there was a whole series of vampire boyfriend stories out there, right? So no one has a monopoly on vampire boyfriends. Other people can write books in that genre as well. So copyright doesn't give anyone a monopoly in that sense. And the work must be original. And here, original doesn't mean how the term is usually used normally. So what we mean by original in other contexts is that the work must be novel or new or unique, right? That's how people tend to use the word original. That's not how it's used in copyright. In copyright, it simply means that the work must have emanated from the creator, so it must be your work, and that it mustn't, and this is to use terminology from case law, it mustn't be slavishly copied from somebody else's work. So it must genuinely be your work and not be copied from somebody else. That's it. It's a very low threshold. And then there's some technical formalities, and just about everybody qualifies. They either resident or a citizen of a so-called Berne Convention country or South Africa. Now, this Berne Convention is a very interesting instrument which dates back to the late 1800s. South Africa is a signatory to the Berne Convention. And as I said to you, copyright is the cheapest form of property you can own, and almost on a worldwide basis as a consequence of this Berne Convention. So if you've written a novel in South Africa, you'll get copyright protection as soon as you've committed that work to a material form, right? So whether you've typed it on a computer or written it down, and that work, again, it's really mind-blowing when you think about it, gets automatic protection in every Berne Convention country in the world. And that's about, 170 countries, right? Just about every sizable, recognizable country that you can think of is a signatory to the Berne Convention. So your work is automatically protected in America and India and Japan and Brazil and Australia. And according to this Berne Convention, those countries must give you the same level of protection as they would a national of that country under their national law. So similarly, South Africa must protect a Brazilian author like we would a South African author. We don't apply Brazilian law here. That's not what the convention says. We must at least give them the full South African protection. So that's quite something. I know of no other area of law, even intellectual property law, where that's the case. So these are the types of works that are protected by copyright. Unfortunately, I don't have dutiful assistants like the previous professor, so my slides are rather rudimentary. It protects computer programs and, like I said, music and film and literary work. So I want you to pause on a couple of these works more closely, because I want you to understand that when we speak about literary works here, even mundane pieces of reports or, how can I say, what letters that you write, these all could be protected by copyright. We're not talking about literature, right? You don't need to be Chinua Achebe or Gabriel Garcia Marquez before you get copyright protection. Copyright protects even bad writing. Let's put it that way. It's not concerned with the merits of your writing style or ability. It protects works regardless of literary merit. So we're talking really about written things. So they could be textbook in education, material that you develop. These things could all be the subject of copyright, even the creation of PowerPoint slides. And this is just sort of more illustrative examples of what could constitute a work protected by copyright. Artistic works, of course, these things are things that correspond to your normal understanding of artistic works, so paintings and sculptures and drawings. But again, here, the types of work that are protected don't necessarily mean only those things that you hang up against the wall and that hang up in art galleries, etc. Right? So it could be even technical drawings, the design for something. Architectural drawings, for example, would be protected by copyright. And things created, three-dimensional things created could be artistic works. So another category of work that's protected are computer programs. In a lot of jurisdictions, these are protected as literary works because we're really speaking about the computer code, right? It's written in some sort of computer language, but that's what we're talking about when we're speaking about a computer program. Now, I want you to appreciate that the protected category is not a computer software. It's computer program. So we're confining ourselves to the code. So if you are dealing with computer software, and I want you to appreciate, and you should unpack it for copyright purposes, take a video game. A lot of kids and even adults play video games, or any piece of software that you have on your computer is actually a combination of things. There is the code that forms part of it, but then there's lots of visual stuff, right? For a computer program, a video game, there are lots of visual elements. There's sometimes even music in there. Now, that is a composite work. Somebody might have written the code. That's not necessarily the same person that created the visual stuff. That might be a series of images that get called up by the computer program as somebody is playing the game. There might be a separate copyright owner on the visual images because those would be protected as artistic works. So when you're dealing with certain types of work, you need to unpack who the copyright owner is. So, for example, people, of course, illegally download music or a film. But let's use the example of music. So a pop song is actually, when you download it, you're potentially infringing at least 3 people's copyright in that. There is the lyrics of the song. If it has lyrics, that could be the subject of copyright ownership in the form of a literary work, and somebody may have composed that. Then there's somebody who did the music, the melody to the song. That might not be the same person who wrote the lyrics. Of course, it could be, but not necessarily. Then the actual recording of that performance is protected as a sound recording, which is a distinct type of copyright work. So, and that might be owned by another company. So you could have 3 people suing you for copyright infringement when you illegally download a song because there are different copyrights in that one song. So, who owns the copyright? Now, in South Africa, and this is important for you as educators and employees to know, because like I say, very mundane things, letters, reports, memoranda, even as I tell my students at Stellenbosch University, unfortunately, they might not get much pleasure out of it, but even the exam papers that I set, that contain some fictional scenario, clearly that qualifies as a literary work. And there's copyright protection in there, right? So it's important that you know about ownership and authorship. So the Act defines concepts of author, and I want you to appreciate that the author is not necessarily the copyright owner. That is the point of departure, but there are important exceptions to it. Generally, for things like artistic works and literary works, it's the person who first creates the work. But you'll see that in relation to other types of work, the Act has a peculiar definition. And so, for example, in relation to a computer program, it's the person who exercises control over the making of it, and that might not be the person who actually writes the code. That's all I'll say on that. So there is case law on that. So now we're speaking about ownership. And generally, the author is the owner. However, there are very important exceptions, and for employees like you and me who have an employer, things that we create in the course of our employment, and of course relate to our employment, Although we are the authors thereof, the copyright owner is our employer, right? But of course, it must relate to my employment. So, as I said to you, the exam papers that I develop, clearly that's part of my job. I have to examine students. The university would own the copyright in that. That's what the Copyright Act says. However, if I write smutty romance novels in my spare time, that's clearly got nothing to do with my employment as a law lecturer. That clearly belongs to me, right? So it's work that is created in the course of your employment and relates to your employment. Copyright belongs to your employer automatically. Most contracts provide for it contractually as well, but even if there was no contract to that effect or written contract to that effect, the Act makes that provision. And then in relation to certain types of commissioning, so where you pay somebody else to create a work, the paying party, the commissioner, becomes the copyright owner, but it's very specific, not related to all types of work, and you need to be wary of that. And then works made under the direction or control of the state belong to the state, but that's also, it must be really directed and controlled by the state. But that's rarely the case, because mostly it's as a consequence of employment that copyright doesn't belong to the author, but to the copyright owner, to the employer. I'm running out of time, so I just want to get on to things that you may be more interested to hear. So what do you get as the copyright owner? As the copyright owner, you get this bundle of rights. And the Act sets out what you get as the copyright owner. You know that girl that writes the book? What does she get? She gets this bundle of rights, and the Act says that no one else can do any of these things without her permission, because she's the copyright owner. And, for example, no one can reproduce the work without her permission. No one can publish it without her permission, or turn it into a movie without her permission, right? So that's her rights that she gets. And she can decide how to monetize that. She doesn't have to monetize it, but she can charge for it and get royalties from a publisher, etc. That's what she gets. That's what we're talking about, this property that she gets. And that's where, of course, issues of AI come in, right? Because when AI systems use other people's creations to train their big, large language models and images, etc., the systems that train these large language models and other generative AI systems are actually reproducing the work. And they arguably had no permission to do so. And that's where the copyright fights are coming in. So these are what we call the restricted acts, or the exclusive rights that are given to a copyright owner. But and primary infringement, how do you infringe copyright, is when you do any of those exclusive rights, exclusive acts that belong to the copyright owner, without the copyright owner's permission, that is copyright infringement. And it's no-fault liability. So it doesn't help you to say, well, I didn't know the work is protected by copyright. Okay? But the Copyright Act, of course, does provide for certain exceptions. So provides for exceptions in Section 12 of the Act. So, for example, you can make fair practice exceptions. I'm choosing my words deliberately here because I don't want to use the word fair use. That's what is proposed to be introduced under the legislation in South Africa, and I am principally opposed to it. That's my controversial stance for today. So we have a system that's followed in 97% of the world, has a system of fair dealing, which sets out specific exceptions. So, for example, we have a system for exception for research or private study, for criticism or review, for reporting current events. You can infringe copyright, provided that it is for that specific purpose and your use has been fair. That's what our current law is at the moment. What the government has proposed, and who knows why, I've been trying to find answers to it. No one has given me a satisfactory answer from government because there wasn't a proper process followed, but there's a bill that proposes we adopt the American system of fair use, which is a very open-ended system. And of course, I know who it favors most. It's a big tech companies who largely tend to be American, who have this open-ended system that any potential use can be found to be acceptable by a court, right? So it will involve you as a copyright owner, sort of a David and Goliath fight. And quite frankly, most South Africans just don't have the money to litigate about whether a big tech company is entitled to do what it's done. They'll just litigate you to death. And that's my problem with what's being proposed. We are eroding the protections of South African creatives. And my answer is why? Who thought this was a good idea? And this thing becomes, of course, a heightened problem now with AI. Like I say, we might not have the AI systems that they have, but we have content that they want to train these systems on. And under a system of fair use, they've just gone ahead and taken and scraped the internet regardless, because, and that's why there are big litigation fights in America. The New York Times has sued OpenAI, etc., saying, you've just really stolen our content to train your large language models and generative AI systems without our permission. And OpenAI and these tech companies have said to these people, it's fair use. Take us to court. And of course, that's what's happened now. This huge litigation in America. Who knows whether we'll get the answer to that? But that's the interplay between copyright and AI and fair use. And that's my concern. And you are creating our future writers, our future creatives. And that's why I think the education sector really should be asking the government some serious questions about what's being proposed here. And these wide exceptions for education, I think, are uncalled for. We are killing off a whole sector of publishing in South Africa, possibly. And don't get me wrong. As you've seen, there's nothing wrong with, if government thinks textbooks are a problem, etc., then hire people from amongst your community to write a book. You pay for the author, you write it, and then you say, well, we've paid for it and now we make it freely available. But don't rely on and sort of ride roughshod through, publishers' rights in this exercise, because it's not about money, right? It's not about money. It's about the principle, because in a few years' time, if authors and publishers can't make money, we are only going to be left with foreign content to prescribe in classes and universities, etc. And then we're going to lament in a generation or two's time, but no one writes for our context. Well, if a writer, an author, a musician can't earn a living, why do you expect them to produce anything for you? Right? So that's my concern. But my time's up. I'm happy to field questions later. Thanks.
Thank you, Prof. Grab a seat so you can join us for the discussion. Ladies and gentlemen, can I now please call upon Ms. Zet Njoza to talk to us, of course, about employment equity and bullying in the workplace.
Good morning, ladies and gentlemen. Good morning. How are you? Well, thank you. I'm used to moving around. Now I think, yeah. I'll see. I will improvise. Thank you so much. I just want to take this opportunity to thank the Secretary General, the chairperson, for the invitation. And I've been introduced, really, I'm Zoleka Njoza, and I see that this morning I'm sharing a podium with my Professor van der Walt. It's good to be here. I am going to be quick, colleagues, and as I was preparing my slides, I've got a daughter that is 27, and she was like to me, Zoleka, your slides are so many, and then I was like, remember, I was once a teacher, did you? Yeah, I started teaching in 1997 until 2004, and then a teacher in me just kicked in. And then I was like, the information that is here is going to be crucial for you so that you have a reference point, especially if we talk about, especially the issues of harassment at the workplace. And I believe that at the end of this presentation, one thing that you need to take home is the fact that the pandemic has taught us that there are other things that we need to learn, others we unlearn, and others we relearn. So I guess this presentation will really assist in that regard. And if I had time, I was really going to do some check-in, but just for a few seconds, Program Director, I forgot to greet you. Hello, Budi. Hi. And then it was more to say, I wonder what zone are you in this morning? So I came up with the different zones. It's a pity that my professors are not going to be able to see, but there is a blue one, there is a green, and there is a yellow. You can see, you can see. Thank you. And then the blue one was more to say, it's Friday today. When we arrived in Cape Town, it was very cold. And seeing that this is the last day. And then the blue, are you happy? Are you calm? Are you feeling okay? Focused, lost? And then green, sad, sick, tired, bored. Your yellow, are you frustrated, worried, silly, weak, excited? And then red, you are mad, you are angry, you are terrified. So it does not mean that there's only one zone that you belong in. It can be two. It can be a combination. But this is by the way. So let's just introspect. And then one will ask a question, why do I have to know about harassment? And this is very important, colleagues. It could happen to you. That's very important. Number two, it could happen to someone you know. And we'll talk more on why do you choose to be a bystander. Number 3, you may be accused of it without you knowing. That's why it's very important that out of this presentation, there are really other behaviors that we need to unlearn because you may or you might be accused of it. You may witness it, even if it's not happening to you. But the question would be, am I holding my peer accountable for whatever behavior? So you may have to witness it. You may have to handle a complaint. This one goes to our managers, our supervisors, our HODs, our principals. And as I will be sharing, there is a case law in terms that is solidarity vis-a-vis SAPS. And the reason why I'm going to share that particular case law, Prof, for me as Uzolega, it becomes a game changer where now it's a bottom up. Because we talk about horizontal, we talk about the vertical harassment. But at a particular point in time, even if you are junior, you are capable of bullying or harassing those that are senior than you. So that will be the case law that I'll be sharing with you. So this is just to give some context, because everything starts with ILO. I just want to highlight that as a country, a member state to the International Labour Organization, before I share some stats that, especially in Africa, how many member states have ratified the convention that talks to elimination and prevention of violence and harassment of men and women in the world of work. It's a pity that, Chairperson, this is not a workshop. I wish that it was a workshop where I was going to be given maybe 2 hours to talk on harassment, because it really impacts on us, especially in terms of health. And then there were about 12 highlights from ILO that, or maybe for our country as South Africa, why did we have to ratify Convention 190 instead of choosing to go the recommendation route? 1, the prevention and addressing of the rise of violence and harassment beyond the physical workplace. And if you zoom into many of our conventions, especially that we have ratified, you talk about HIV/AIDS, you talk about disability, especially the codes of good practices that are more housed in the promulgated under the Employment Equity Act, you will see that ILO is more preaching the world of work instead of the workplace, because we need to go beyond the workplace. It's more to prevent and address the cyberbullying and mitigation, colleagues, of the impact of domestic violence on the world of work. And it goes further to say to protect those even more exposed to violence and harassment in certain sectors. And the reason why I'm slow in reading this, DG, is the fact that the employer has a responsibility of creating an environment that is conducive, that is free of harassment. And then it goes further to name some of the sectors, and then education sector is there. Because if there are other forces, the externals, the parents, members of the society, that you are more likely to be abused, maybe in language, the language that are using towards you, whatever the case. But the environment will be hostile if you are not protected. It talks to the other sectors like your working arrangements, health and transport. It was just to name the few. So that was the reason to say, as a country, we decided to ratify rather than go for a recommendation. Because once we ratify a convention, it gives us a legal obligation as a country to say, let's go back and enact a legislation. So that is why we are having a code of good practice that talks to prevention and elimination of harassment in the workplace. And as I think in 2018 or 19, I was given an opportunity to go to Geneva and as was one of the delegation on the very same convention. So as we were sitting in the Africa room as government, because Labour was there, all the social partners were there. And then I was so shocked when I checked the stats to see that Uganda is one of the member states that have ratified Convention 190, because their issue in that room at the time was more around sexual orientation. Because the 54 member states in the continent were like, we are against having sexual orientation into our codes of good practices when we are going back. And then the issue was like, what do we do as South Africa being part of Africa? Was more to say, in the Bill of Rights, in the Employment Equity Act, Chapter 2, you are protected. It's one of the prohibited grounds to say you may not unfairly discriminate me based on sexual orientation. So we are part of the 9 African countries that have ratified. But the stats is still slow, and because the adoption happened in 2019 of the convention, out of 187 member states at ILO, only 44 that have ratified the convention. It's just a bit of history, colleagues, to say the Code of Good Practice really is more promulgated under Employment Equity Act. It's just to give some statistics, and then I think that because you do have access to the presentation, you can go through it, but this is under the Convention 111 that talks to discrimination in employment and occupation. So here is our constitution. It was so interesting, Professor. I was listening to the former judge on the first day when he was more giving us a history of where did we go in terms of benchmarking purposes, to say that the Canada, the India, who contributed to our constitution. So I love the constitution so much. When I do my presentations, especially in the employment equity space, I do not leave the constitution. So the Bill of Rights does protect everyone. So this is the legislative framework. This one I'm gonna spend maybe a minute, because when we talk to issues of harassment, we must not only focus on employment equity or maybe focus on the constitution that I'm protected, you have to protect my human dignity. But we have other pieces of legislation that really talk to violence and harassment. We have our constitution that everyone has inherent dignity and have their dignity respected and protected. So we are protected. We have our Labor Relations Act that will say any form of violence is misconduct. And then we have our Employment Equity Act that under Chapter 2 that talks to prohibition of unfair discrimination. Any form of harassment is regarded as unfair discrimination. So once you bully me based on all of those listed grounds, you must know sitting here that it's not only about my dignity, but you have also unfairly discriminated me. And then I want us to talk about the occupational health and safety, because as an employer as well, you have a responsibility of creating a workplace environment that is free of hazards, that is safe for each and every employee. But it goes further to say that violence is a form of misconduct, that was LRA, and violence and harassment is a health and safety hazard. That is why you'll find out that when you joined teaching in 1986, for example, or maybe I joined teaching in 1998, now here comes 2004, all of a sudden, I'm struggling in terms of anxiety. I'm so scared of this person and that person, and my high blood pressure. When I entered, I had a very clean, good health. But now you are sick. And the sickness is not caused by any other thing except that by the environment that is hostile for you, that is so toxic. But because now we are having other pieces of legislation, you ask a question, if in terms of COID, you are protected in terms of injuries. I wonder, in terms of mental illness, am I covered as an individual? Because whatever that you are suffering from, you have contracted from the workplace. So there are other colleagues, other pieces of legislation, but that talk more to the harassment at the workplace. I won't talk more about employment equity, but it's just that in terms of my topic, we wanted to link it to employment equity because it falls under the Employment Equity Act, that is the code itself. But we all know, colleagues, that why are we having employment equity in the country? And when you look into the purpose of the legislation itself, it's mainly to say, how do we plan to make sure that we prohibit the unfair discrimination? So it talks to prohibition of unfair discrimination, and it will have all the listed grounds. And then in the amendments of 2014, we see the legislatures bringing the arbitrary grounds. And that one, it gives the responsibility to all the employers, regardless of size. Because in terms of complying with employment equity, affirmative action specifically, you must be a designated employer. But it's just to say, on our ways to say this is employment equity, and we understand its elements to say that that is prohibition of unfair discrimination, and the fact that we needed now under Chapter 3 to say how do we plan to redress the imbalances of the past. That is why we are bringing the affirmative action measures. But I want to believe that the DG does comply, has a plan for you to say this is how I'm planning to transform the department. This is the code of good practice, colleagues, and you will see that there's a lot of information, but it will be just by the way to say that after really we have ratified, we're given by ILO 12 months to enact legislation. So we are having a code of good practice. More than anything, is more to align ourselves to, as a member state, to ILO. So we will be talking about the scope and application and every legislation. I was once an inspector, and I was enforcing employment equity, including the PCA, that has some sectoral determinations as well. So you need to understand that even if you are an owner of the company, when you get into the Employment Equity Act, you'll find out that it does have some exclusions. Not every employer in the country must be compliant with the provisions of affirmative action. And then I'll talk about your NIA, your Secret Service, and others, your Defense Force, that they are excluded. But this code applies to everyone. So we talk about the owners, we talk about the job seekers that are more likely to be the most vulnerable. The applicants, and as I was sitting yesterday and listening to the speakers, that there will be educator assistance or education assistance. And then I'm thinking that even if you're an applicant, under Chapter 2 of Employment Equity, especially Section 9, is saying an applicant must be regarded as an employee, meaning that you may not unfairly discriminate. So I'm thinking that there will be kids that are coming, are joining the labor market. How ready are we in terms of onboarding them or socializing them on the policies? And you must remember now, out of the code of good practice, the expectation or the legal obligation of the employer is to draft an employment policy that talks to issues of harassment. And I'm standing here, DJ, and then I'm asking, if we do have a policy, how many in the room know about the policy that talks to harassment? And if you know the policy, because it's not really enough to say, I've seen the policy, what is the content? What is there? What is the stance of the employer in terms of saying, I'm having a zero tolerance against harassment and violence. No one may do this and the likes. So you need to understand the stance of the employer that this is not what I will tolerate as an employee. So is there a policy? Do you understand what are the contents? And has this policy been socialized to the employees to say, there is a policy. I know where are the reporting mechanisms. I know where to go should I feel that I am harassed. So these are the things that we will be talking to the DG. Whether do you have? It talks to your clients. How do we protect you? That's why I've made mention of the hostile environment. That if, for example, there are other external stakeholders that are getting into your workplace, are you protected against those? So it talks to your contractors, other people that are having business dealings with you. And then these are the situations, colleagues, where the code may apply. And the reason why ILO is more, their focus is more on the world of work, because you are not in the workplace now. You have attended a seminar. So if you are here and everything is controlled by the employer, meaning that for you being here, accommodation was paid for you. The flights were paid for you. You must remember the time that you are spending here is a resource for the employer. So meaning that regard yourself that I'm still at work. So these places, colleagues, are both public places as long as they are controlled. It can be remote working at home. We are talking about places where the employee is paid, takes rest, meal intervals, where you're having meal intervals, your canteens, work-related trips. This is one of them. Travel, training, events, and social activities. Employer-provided accommodation, as long as it is paid for by the employer. When commuting to work, other companies are using taxis, for example, to say, I'm moving you to the other destination, as long as it is controlled by the employer. Work-related communications, the emails that you are using, and they are carrying the brand of the employer. Consider that this is the situation where this code may apply. What is harassment? Okay. Only Lipeli. Where do I go? What's going to be critical? Because I have only 10 minutes. It's harassment. The other things are so tricky. Because sometimes issues of harassment or bullying, your intuition sometimes does kick in. You will see what is right, you will see what is wrong, even if I'm passing a joke to you. Immediately you pause and say, "Ay man, whatever that is like was saying, I think something is not right." But you have the presentation, colleagues. But it talks to the unwanted conduct that impairs dignity, which creates a hostile working environment for one or more employees. You will know when the conduct is unwanted. And then it goes to say it includes violence, physical abuse, and it talks to psychological abuse. When you feel that I'm so intimidated, such that I feel there's some sort of a fear. And then it goes further to say sexual abuse. I wanted us to talk about the sexual harassment as well. And harassment is an abuse of power, particularly affects vulnerable employees. The applicants that will be coming have poor access to exercise the labor rights. These are the types. Maybe sometimes you didn't even know that, hey, was I really harassing? It was just a joke. These are the things that we need to unlearn. And that's why I thought in this presentation, let me bring all of these examples. That we're having physical, there is verbal, psychological one. And there is bullying that involves abuse of coercive power by the individual in the workplace. Horizontal employees, harassment, where you feel that we are on the same level, but for some reason, Ubanban thinks that is better than us. Like you're not being bullied by your head. Or maybe I talk supervisors. I once worked for Transnet in Labor Department. We talk supervisors. Maybe at your level, we talk about your HODs. Or maybe we talk about your principal. It can be the SGB. But when we talk about the horizontal one, we are on the same level. But I feel that I can't go to the office. I can't go to work because Ban thinks that is better than me. We talk about the vertical one. Now, this is the one that we are reporting to. And then intimidation. So these are all types of harassment. And then you go to the passive one. You see those that are covered. The ones that are so subtle that it takes you a minute to think that, hey, Ubanbana, I don't like the language. We need to unlearn other things. Even if we are passing jokes, it cannot be at the expense of the individual. And the fact that it impairs on your dignity as an individual. So these are the things. Mobbing, and employees do mob. Even if you are at the same level mobbing, whether against the principal, the HOD. And when you get into the meetings, it does happen to say that sometimes I'm sitting, Ubanban is presenting, and then those condescending eyes that you're not saying anything, but yes, bonane. And then the eyes is over in the room. That is harassment, colleagues. We need to unlearn those. And then it goes to say that mobbing, the case that I'll be sharing with you, the online harassment, we're ever having the WhatsApp groups now. Banban is an admin WhatsApp group prof. And then it does happen. Cyberbullying does happen. The hostile environment that we need to make sure that the environment, the workplace environment that you go to on a daily basis, that you are protected. And then this, I always say, what it is not, because we can have all of these definitions because they are there and you'll be going through them. But we need to get to a point to say that, is this really bullying? And then we go to say that. I want to start about the disciplinary actions. Everyone was talking about discipline, the disputes and everything. That if you are being disciplined because of poor performance or underperformance, especially if there is performance management system that has been followed, you can not go around to say that I am being bullied. And then it goes to say the arguments, constructive feedback. I have to give you a constructive feedback. And you will know if it's not constructive, but it's more to embarrass me. It's more to demean me as a person. So you are an adult. You will know if something is fishy. So these are all to say that this is not bullying. So you are expected, colleagues, to perform and do your part. So there is a definition on bullying that goes further. It talks to the workplace violence. We cannot exclude violence. But we need to ask a question now to say, why do people bully? Now we want to assess you as an individual. And you know Ubanbani, that Ubanbani is a bully. Sometimes we just say it as a joke. But we are bullish, as if Ubanbani is here, you are a bully. That is not right, colleagues. You cannot feel that you are being bullied or a person feels that is superior than you. So we are saying now, why do we get into you now, we become psychologists because we need to assess you. Whether are you being bullied at home? Now you feel that, okay, now I'm given an opportunity, I'm superior than Ubanbani, I can really infringe your rights. Mimicking behavior, social dynamics. Sometimes you do it because of the revenge and retaliation. Lack of boundaries. You don't know how to set boundaries. You can't even read the room. Olivia was like, Zolega, as you get into the stage, please read the room. And then we talk about the personal issues. And I was happy as I was listening to you, profs, to say yesterday, we need to have social services at the workplace because it has to start there. And as I was working, I'm not sure in the space of education, I taught for 7 years. So if you're sitting there, who's helping you as an employee? Because I worked for Transnet, I've been in the Department of Employment and Labor at head office. Wellness is just same floor. So where is your wellness? Should there be something? Who do you reach? Who do you talk to? So these are the things that we need to improvise. Sometimes there are justifiable reasons. It's very important that I mention them. Program director, that I bully you, and then others will even justify on my behalf. No, it's just a clash in terms of personalities, personality clash. And then others will say, no, it's provoked by the harasser, the person that is harassed. And then it is a defense leadership style. That I get into the workplace that you need to understand. We all understand, everyone, we are unique. We all come up with different leadership styles, whether being transformative, whatever the case. But it cannot be a justifiable reason that, no, this is who I am. You will do as I say, this is Zolega. That's not my home. I cannot say that I'm imposing my leadership style on you, knowing very well that I am demeaning you as a person. And then there will be those precautionary tales to say, no, man, it's a reasonable expectation, it's a company culture. And I want us to talk into issues of company culture. Because we talk in terms of employment equity, whether is there a corporate culture. And if we're talking about values, and I know that at school, wherever we are at the workplace, we talk issues of race. We talk issues of ethnic groups. And as I'm reading most of the cases, you'll find out that more focus is more on race, but we shy away in terms of ethnicity. That is very important that we do not shy away. And as you are sitting here as a teacher, do you know what are the values of my department? Because each and every department, you check the annual reports. I've worked for companies and then we found out that, yes, these are the values. It's not enough to say that one of the values is responsibility. One of the values is respect and care. But how do we plan to embed those on you as employees? And what are the behavioral statements that are expected from you as you enter the workplace? Because everyone will be like, no, Yirali, I'm coming, I'm bringing my own value because I'm from Gqeberha, I'm Xhosa. There's another person that is Tsonga, there's another person that has grown up in the rural area, in the urban. So we are bringing. So the problem would be now the challenge. If in this space, we do not define our values so that it becomes easier for us to mirror those values so that we embed as well those values to our school children. So it's very important when we talk to issues of culture. And as we were busy with pandemic and the likes, I was like, we always, when you start meetings in the past, you remember in the past 2 years, before we start a meeting, there will be the health safety issue to say, okay, this is what is happening. We are reminding you of the health issues. But can't we have a moment we pause when we start meetings to say, what is our culture? What are our values? And what resonates with me today as I'm entering in the room? If we talk about respect and care, I don't think that I'm capable of harassing, of bullying you, because I know what respect and care means. So these are the things that we need. Diambe? Dikabin? Thank you so much. This one. This one. Maybe this one.
Yeah.
Okay, no, you do have the legal obligation for you, DG. A microphone. Oh, the move. Sorry. DG, this comes to you. The last one comes to DG. This is for you. Section 60 of the Employment Equity Act. You have a legal obligation that there should be a policy. And if you are sitting here as an HOD, as a principal, as a union member as well, that I think that there needs to be some education around issues of handling harassments, whether sexual violence. That should you not attend to the issues, DG, and we must remember, there are components here that when you bully me or you harass me, it does not have to be persistent. You do it once, I take you on. You don't say, Marazoleka, I just said it once. You don't create a dossier. Once, I take you on, and you deal with it, DG, immediately. And that's why there is a case that talks to solidarity vis-a-vis the SAPS, where Colonel Oosthuizen was racially harassed by those that report to her. So, I guess I'm done. Yeah.
Thank you so much. All right, ladies and gentlemen, we will now open the floor for some engagement, and I'm going to take one round, unfortunately. So can I ask that we take one from this table, please? Okay, we'll go for two. And then that table there, and there's a table there. Sure, DG. I'll come to that table as well. Yes, doctor, I'll come there as well. All right. So here, and then there's another hand there. That table there. Yeah. Go ahead. Short and sharp, please.
Right, I can, okay, I've got that started. I'm addressing myself, good morning, I'm Basil Manuel. I'm addressing myself to Professor Kajika. I just want to lament a little about contextualizing fair use only to big business and big tech only. I think it's a great pity because, of course, in the context of South Africa, in the context of our tech-poor country, particularly when it comes to our children, in the context of our schools being the way they are, fair use means other things too. And it's a great pity that it was balanced in the other way. I know you had a brief, Professor, and I know you spoke to that brief, but those throwaway comments do create the impression that it's only about one thing and not about all the other things that we've also been speaking about. And I do agree, we must recognize people for the work they do, but there's another picture on the other side. Thank you.
All right. Okay, we can take you.
Thank you so much. I really appreciate it. Good morning, everyone. I'm Azaf Morin. I'm from Mounthosa. I represent our clinic and CT sector. It's day 3 of this wonderful, beautiful, amazing event that we are participating in. And I have to take this moment to just comment and say, qualified clinic and CT lecturers pay the ELRC levy every month. Yet we have now come to day 3, and I have not once heard the words college, lecturer, or student, except for Professor Van der Walt. Thank you that warned us against befriending our students on social media. In basic education, all the employees and service providers had to go through in the process of getting police clearance. However, this is not happening in our sector. Some background. Higher House to be Keely Finger shared the study they did in the post-school education and training sector at the Safety and Security Minimum Norms of Standards Workshop in November 2023. 10% of all rape cases nationwide are reported in the PSET sector. 60% of all service staff feel unsafe in PSET institutions. 71% of all academic staff feel unsafe in PSET institutions. We don't want special treatment. We plead, no, we insist on getting the same treatment as school educators.
All right.
We don't teach kids, we train young adults. Section 29(1) grants our students the right to further education. We are fully aware of the court case that Nahawe brought to move us to the GPSSPC. We don't want to move. We are educators at heart, but we are also tired of being excluded and ignored and of being bullied into silence. So from now on, we are prepared to be much stronger. ELRC, everyone here, please take our hand. Let's grow together. Moto ki moto, babato babangwe.
Thank you so much. Let's bring it to the side. There was another hand. Yeah, go ahead. Short and sharp.
Thank you, Program Director. Let me take this opportunity maybe to thank Council for coming up with this indaba. Well, I'm Setati from Beu. And I think the idea to come up with this indaba is to assist Council in minimizing a dispute in a way of creating everlasting labor peace. And we have observed, allow me just to make some submissions which I wanted to make yesterday, but we could not all speak or make submissions. One, Chairperson, that some of the disputes which ends up at arbitrations could be resolved at conciliation. Conciliation is one process that can end disputes without costs and waste of time. And this is being overlooked in most cases where you find that employer party in some instances will say that he does not have a mandate. Can't we empower the arbitrators to have that power to enforce that conciliations be considered? And also to DG, you have in your administrations HODs who will be players and referees at the same time, appointing an initiator and also having a chairperson coming from the same department. And you will find that these people are doing one another favor, even where facts are clear. We need chairpersons who are neutral, maybe coming from a circuit or another department.
All right.
That will ensure that we do not have disputes. But now for today's presentations, just some few comments, and thanks so much to the panelists who
Can
have
you
been.
take one, please, my good sir? We
Wow,
press
wow,
for
wow,
time.
wow. Oh, thank you.
Yeah.
But in conclusion, I wanted to tap into what the GS has indicated in her recap, that from here, how about if we can assemble a team that will process all the engagements and proposals that we have so that we can have a way forward. Moving from here, thank you so much.
All right, let's bring it to this end. Just a quick one as well, DG.
Let me try. Somebody said, am I snatching my right of reply? I'm not. Thank you for the privilege, Program Director. Let me start with Professor van der Walt. I must thank all of them. Their presentations have been great. I wish I could stay for the whole month listening to you and unpacking every topic that you covered. So I really must commend you for that. Now, the issue of the social media is not only a problem to adults, it's also a problem to children. And I think first, children are not equipped to responsibly deal with the social media space. Adults are also not equipped to deal with the social media space. And my view is that an ongoing public education to parents and children is very important. What can we do to make sure that we run this public education to parents and also to children? But in terms of adults in the workplace, as employer and employee organizations, and that's why I'm applauding SACE, but that shouldn't be an episodic thing like this seminar. It must be programs that are sustained in the workplace by both the employer and the employee party. I would want to get your view on that. And then Prof. Kajiga, I was just wondering, in terms of the notion of copyright, I thought that education is a social good. And essentially, when you use materials, you are not necessarily making profit. But I just want to find out that it doesn't really matter whether you use it in the interest of social good, as education, or whether you make profit, you are guilty anyway. You treat both the same.
All right.
I just need my ignorance to be. The last one, this is Zoleka. Also enlighten me on this one. The policy on employment equity and on sexual harassment. I thought a school is a workplace. The department can have a policy to guide several areas that are deemed to be workplaces. At provincial level, they need to have their own policies. Up to at school level, it must delineate and cascade up to school level as workplaces to have their own policies. Thank you.
Thank you so much. Okay, Prof, go ahead. Let's get your reflections and responses, yes, to some of the comments, yes.
I don't know if this is not on, is it?
It's on.
It's on. Okay. Thank you, DG. I've only got the one difficult question. Like a true lawyer, I will say, the issue of pupils and learners at schools and how to address the problem of the abuse of social media with them is not within my brief. But I agree with you. I mean, I would imagine, and we know, I mean, we see that in the news all the time, is that the abuse of social media at the level of the learner has really gotten completely out of hand. And I agree with you. I mean, you suggested the answer is that advocacy and training and engagement with parents and school governing bodies and at school, as you say, is of utmost importance. With reference to the educator and other employees at the schools, I think that, in my view, again, we have the examples of the ELRC really tackle the bull by the horns in many respects and negotiate collective agreements. Now, what I suggested in my talk was that we should look at soft law, but nothing prevents the ELRC for this particular sector to discuss, negotiate, and in fact develop its own code of good practice that could assist and address, and then go on a sort of campaign of spreading the word, as it were. The unions also have an important role to play here, and I referred to the newsletter that just by chance, this was published this week by the SAOU, and that's a very interesting and particularly useful document that assists their members. So clearly from the advocacy and training and making aware point of view, the unions, all the unions in the public education can play an important role. Thank you.
Prof. Kajiga, just a quick one. Yes, you are.
Okay, thanks. About the question about education, you're right. My brief wasn't to speak about copyright in relation to education per se, but I have in other fora addressed the issue of education. So our Copyright Act, like I said, provides for exceptions where you can technically infringe copyright and that it's permitted. So for research or private study. Our Copyright Act does need revision, no doubt about it. Technology has changed the world. We need to find new fair dealing exceptions, and that's my proposal, to have new, more directed, specific, bespoke fair dealing exceptions. But this broad sweep of exceptions where we won't pay for educational material is, I think, preposterous, to say the least. And there's a reason for it. Education and what we try to achieve through education is not a one-shot game. I think government needs to understand that. And what I mean by that, why do we educate people? We're speaking about the fourth industrial revolution. The game has changed. We want people to produce higher order creations. And so you must cultivate the environment in which people see the value in using their intellect, and that their intellectual creations will be respected, and it's a way for them to earn money. Why do we want to create a second class of creatives here? Don't our creatives, don't our intellectuals need the same type of protection that they do in Europe and America? Don't they need to feed their families, put a roof over their head, clothe themselves? How would they earn money? Do you think they're just going to write for the public good? It's, you know, we are, in a sense, killing off what we purport to want to develop.
All right.
And that's nonsensical as far as I'm concerned. It's not a one-shot game like, let's make textbooks free today. No one earns money from it, but we think that in the future people will write textbooks somehow magically. I'd rather open a chicken tikka store rather than write books if the government was just going to expropriate my rights, right? Because at least then I know the money goes into my pocket. I'm not going to sit there night after night writing, trying to produce intellectual creations.
Okay, Mr. Joza? Let's also get a quick one from you now. We're wrapping it up.
Okay. Thank you, DG. Yes, you are correct. A school is a workplace because if I report to school every day, that's my workplace. But I think for me, as an accounting officer, is really to ensure that each and every workplace does have a policy. And it's not only about drafting a policy and that the policy is there, but have you socialized the policy, especially the contents of the policy, to the employees? Because really the stats has shown to say that, yes, there is a policy, but how many know about the policy? Even if they know about the policy, have they even perused the policy to understand what are the contents that are in the policy? So socialization is very important. Thank you so much.
I must thank you so
Prof.
much, panelists. Thank you so much for winding it down for us today. Thank you so much. And of course, we have the gifts. I'm sure GS as well as the chair are going to come up to hand them over now. Ladies and gentlemen, this concludes this section, but of course, also, we will be getting the vote of thanks from the chair in just a moment. Bernice, please come through for the photo. Thank you so much.
Thank you, sir. That was your easiest week.
Is that a self-assessment?
Yeah?
No, you can go.
Go.
Oh, she wants a picture.
Thanks.
Ladies and gentlemen, let me just start off by thanking the last speakers and perhaps doing a 30-second reflection. Professor van der Walt, I don't like WhatsApp groups because no matter how formal they are, work-related they are, people can't resist the urge to send jokes. It starts with jokes and then funny pictures, and ultimately we can't separate what is work-related and what is personal. But there's a family that was bereaved, and they formed a WhatsApp group. And then the person, the administrator of the group, wrote a note that we must all contribute 2,000 rands towards the burial. And then the uncle left the group. Then the administrator added the uncle again. And then the uncle left the group again. So that's the problem with these WhatsApp groups. But thanks a lot. I do think that we need a code of good practice on the matter to deal with the issues. Prof. Kajika, whilst you were speaking, I had to go to my statement of the courses that I did at university just to check. You'll be happy that I did intellectual property as an elective. It's certainly not mainstream. But I do want to suggest that you speak to the two ladies at the back so that you stop using VHS, cassettes and discs. Today we keep videos and music on our phones, and at worst case scenario, USB or USB-C. Zolega, indeed, the employer must create a safe and conducive workplace.
And yesterday, you would have been testimony of the how unsafe schools have become. I'm not going to go back to what Dr. Maluleka said about Mboro. I shall leave it at that. But I want to leave you with one thought. I battle with the test for harassment because it's subjective. The exact same conduct done to A and B, they receive it differently. But we leave it at that. Ladies and gentlemen, we have come to the end of the event. One for the history in our books. I want to thank all the speakers and all the attendees for a special and insightful event. I want to thank our program director. Thank you. Thanks a lot. So you handled everything perfectly. And also in absentia, Prof. Metcalf, who's not with us today, who facilitated the sessions yesterday and day before yesterday. I want to thank all of you for the participation, and I wish you safe travels for those who will be traveling today and for those who will be attending the AGM as well as the gala dinner in the evening today. We do welcome feedback on how we do things, and Basil, in the appropriate time, will also respond to those issues that are raised. But ladies and gentlemen, this concludes our program. I thank you. Just one announcement. One announcement. AGM starts promptly at 1. I'm sure you all know me. At 1 o'clock, we'll be starting, with or without you. The AGM is in this venue. We're moving to it. All those who are attending AGM, please 5 to 1, 12:55, be seated so that we can start with the AGM.
And another quick announcement, ladies and gentlemen, just a quick one. We implore you to also attend